Good evening, my fellow Andrew Sindler SSD Attorney YouTube channel viewers. This is Andrew Sindler in the virtual flesh. Good evening. Welcome to all of you. It's been a while since the last video. I hope everyone's well. Had some exciting times, including a presentation just like this one, only it was done pretty much the way I envisioned this to originally start. It was done as a live stream that I did with a colleague attorney of mine. I'm hoping to do more of these where we were taking questions in real time. And this was from existing potential new clients and just people that were genuinely curious about how the Social Security disability process works. So I'm hoping there'll be more opportunities for that, and maybe even to offer some of you. My viewership is starting to grow, and definitely looking forward to continue relaying information both in real time and in pre-recorded sessions just like this one. Also had the opportunity to do a presentation for the National Organization of Social Security Claimants Representatives in San Diego. So great turnout. Was able to make a little mini vacation out of it. And just we're continuing to rock and roll here. So it's going really well. And just continuing to come up with new relevant topics for everybody so that we can cover everything we need to as we need to. So, without further ado, let's get to tonight's topic. Okay, here we go. Well, I hope you enjoyed it. I'll see you for the next one for the sequel. Okay, I hope everyone figured out that was a big joke. But it seemed like an appropriate starting point and launching pad for tonight's topic to be continued. While it does frequently pertain to sequels of movies, books, TV shows, it's not quite what we're talking about for tonight. We are talking about disability cessation and continuing disability reviews. Now, some of you may be familiar with this topic to some degree. If some of you are on or were previously on benefits, you may have gone through something like this. And it's something that doesn't get talked about that much, particularly with attorneys that take on cases like me for clients that they are trying to get established on disability. But we're going to talk about where we go from there. So as always, my About Me screen, nothing has changed in all the time we've been doing this. So I'll just get this up quickly for everyone's viewing pleasure. Nothing different. All the same. All right. Disability continues, or does it? Social Security disability claims, as we've talked about many, many times, are premised, of course, on a person's ability, or in this case, inability, to work a full-time job consistently. Once you've established that, you are approved for disability and you get your benefits. But how do you go about continuing to prove this once you have been approved? Well, as we've talked about, of course, to get approved initially, we go through the five-step sequential evaluation process. And again, for reference, see my original video that kicked off the channel, the ABCs of SSD. But why do you sometimes have to continue to prove disability once you've established it? Two words: medical improvement. So many medical conditions and impairments, as I'm sure most of you know, with the right treatment can and frequently do improve. And improvement, if it's significant enough, could conclude, Social Security rather, could conclude that you are now capable of working where you once were not, or at least working full-time consistent work. So, does that mean that you can't get better at all in order to stay on benefits? No. I'm not going to say it as emphasized as it's typed there, but it's a resounding no. You can absolutely continue to treat and do the best you can for yourself, and it's okay to feel good on some days too. There's nothing wrong with that. Now, the formal definition under the Social Security regulations for medical improvement is any decrease in the medical severity of your impairments, which was present at the time of the most recent favorable medical decision. And that's important. I'm going to talk about that in a second. That you were disabled or continue to be disabled. A determination that there has been a decrease in medical severity must be based on improvement in the symptoms, signs, and/or laboratory findings associated with your impairments. So the typical way to go about determining medical impairment, of course, is reviewing medical records and seeing if your doctors in their examinations and testing, diagnostic imaging studies, CT, MRIs, X-rays, or lab work, is it suddenly showing in comparison to prior medical records and results, things look like they're improving? And is it more of a steady uphill trajectory of ongoing improvement versus just a one-time static improved in a single moment in time, but then starting to go down the trajectory a little bit? Now, as I was saying, when I highlighted the most recent favorable medical decision, for most people, that's the point in time where they first got approved for benefits, whether you got approved at the initial level, the reconsideration level, or as a result of a hearing with the judge, or even potentially on appeal. But for some people, that can also mean a later point in time after that. And we're going to talk about that as we get further along the slides, because I don't want to get too far ahead of myself on what we're actually discussing here. So let's talk about medical improvement in the ability to work. When does medical improvement actually matter for your claim and award of benefits? Well, the short answer, which is pretty much right there in the title of this slide, is when it starts to impact, or in this case, not impact your ability to work. Medical improvement not related to the ability to do work, which is, again, part of the same definition in the regulations, is if there's been a decrease in the severity of your symptoms, severity of the impairments, rather, present at the time of your most recent favorable medical decision, but no increase in your functional capacity to do basic work activities. If there's been any medical improvement in your impairments, but it's not related to your ability to do work, and none of the exceptions apply, your benefits will continue. So simply put, you can have medical records that show maybe things have leveled off. Maybe they're stable now. They're not getting any worse. They're just not necessarily getting any better. And technically, that's an improvement. But does that mean that suddenly you can start functioning in a better way than you were doing before all of that? And if the answer is no, then it's not a medical improvement related to the ability to work versus a medical improvement that is related to the ability to do work. Medical improvement relating to your ability to do work, if there has been a decrease in the severity of the impairments present and an increase in your functional capacity to do work activities. A determination relating to your ability to do work does not necessarily mean your disability will be found to have ended unless it's also shown you're currently able to engage in our good old friend substantial gainful activity. So in the example of somebody that had a severe surgery, maybe in a transplant surgery, perhaps, and usually there's going to be a significant recovery period while your body adjusts to the new organ or whatever was donated to you that you're now going to be living with and adjusting to. But perhaps suddenly you've improved enough that you're functioning like you were functioning before you had a need for a transplant, and you're able to do things now that you could not previously do. Just as another example, and a lot of times this is where this is more apt to come up. If you have the type of impairment that results in a step 3 meeting or equaling of a listing, and suddenly your impairment has improved enough that it no longer meets or equals that listing, that's where it's more likely to be a determination that you suddenly do have the capability of returning to work, or at least work activities where you previously didn't. Getting a little more bizarre with the animations here. Medical improvement and ability to work continued, since we're talking about continuing disability. Functional capacity to do basic work activities, another definition from the regulations. Disability, of course, like I said, is defined as the inability to do substantial gainful activity by reason of medically determinable impairments. In determining whether you are disabled under the law, we must measure, therefore, how and to what extent your impairments have affected your ability to do work. You do this by looking at the functional capacity for doing basic work activities to see how it's been affected. Basic work activities mean the abilities and aptitudes necessary to do most jobs. And here's a laundry list of examples, not an exhaustive list, but certainly plenty there that you can see for yourself. Continued once again. The ability to engage in substantial gainful activity defined. In most instances, Social Security has to show that you're able to engage in substantial gainful activity before your benefits are stopped. When doing that, they'll consider all your current impairments, not just the impairments that were present at the time of your most recent favorable determination. That's important because just like they're looking to see if there's been any improvement, they're also looking to see if there's been any decrease in functional activity and any worsening of conditions, or in this case, the presence of new conditions. And if they cannot determine that you're still disabled based on medical considerations alone, they're going to use symptoms, signs, and laboratory findings to make an objective assessment of your functional capacity. And they will also consider vocational factors like age or your work history. So you might be asking yourself, what would prompt Social Security to continue reviewing your disability? Well, when disability is determined, the decision maker, whether it be the people at the lower levels or the judges that do the hearings, also have to make a determination whether MIE, medical improvement, is expected, or mine, whether medical improvement is not expected. And they will note that directly into the claim. Specifically, when a claim is approved at the initial or reconsideration stages, this determination is made by DDS in a document known as the Disability Determination Explanation, or DDE, which is contained in the A section of your electronic claim file. And what's interesting about this is that up until very recently, attorneys did not have access to this section of your claim file until the case got to the hearing level and they actually put it in there for the attorneys to see. They have changed that, which is a dramatic improvement for what we can learn about a claim early on. So when a claim gets denied at the initial level or even the reconsideration level, we can view this document to see what the basis of the denial is. But more importantly, when we have a claim that gets approved, it's equally as important to see this document so that we know if they have made a finding whether medical improvement is expected or not expected. As I'm sure you can guess, if medical improvement is not expected, and that's the way they have it noted, it's far less likely that they're going to review your disability claim going forward. But if it's noted as it is expected, then it's quite the opposite. Now, when a claim is approved by an ALJ after a hearing, the determination is generally made within the body of the written decision, and it will only be there if they believe medical improvement is expected. And yet, generally speaking, at the very end of a favorable decision, you're going to see this pretty much in the last sentence of the last paragraph, right before the judge's signature, and it will also note a time frame within which to complete to be continued on the next slide, a continuing disability review, or a CDR for short. So in some ways, a CDR is like a re-adjudication of your claim, as if you're starting from scratch, but in other ways it differs. Under that section of the Social Security Act, there are various reasons why a CDR would be conducted, including the reasons that I gave on the prior slides of medical improvement expected versus not expected. If you return to work, if you report earnings on your earnings record, if you complete a vocational rehab program, and there's several others too, and you can go look up this section of the Social Security Act, just do a Google search, it'll come right up. CDRs can occur as soon as 6 months after disability is approved, and they can be as far out as 3 years or more. And if it's in an ALJ decision, they'll put a time frame as to when they believe it should be reviewed. If a CDR is underway or is in the pipeline and they're getting ready to, you will be notified in writing about it. There will be no surprise to that. You'll always know that they're checking in on you. All right, let's talk about similarities of a CDR to an initial determination of somebody being disabled in the first place. So there's a pretty much very similar DDS process at both the initial and reconsideration stages. It gets assigned to a DDS caseworker. They update your medical records and pull them. They oftentimes will send similar forms like the ones you've completed. Now, more than likely, you won't complete a new work history report unless you're reporting earnings all of a sudden and you've returned to work in some capacity. But a lot of times they will send the function report or some of these questionnaires, the pain, the headache, the cardiac questionnaires, and you may even have to do an updated consultative exam. And of course, as you all know, I have YouTube videos on both of those topics, so certainly feel free to reperuse them as needed. Just like at the initial level, a written decision will be rendered. If the decision results in a finding of medical improvement / non-disability, the exact same appeal steps and stages are available as when you first file a claim and try to establish disability in the first place. So the initial appeal, reconsideration, then a request for hearing, then the appeals council, and so on and so forth. Now, obviously, if the decision results in the finding that you are still disabled, then that's where it ends, and it's no different than being approved for the first time, and just everything continues undisturbed. Now, how are CDRs different from initial determinations? Well, again, as I keep coming back to over and over, medical improvement is the key determining factor. And again, specifically, improvement that would allow for a return to SGA, especially if you were previously found disabled based on a listing. As I said before, if your condition has improved enough that you suddenly don't meet that listing anymore, which in the example I gave about a transplant, if you look up some of the listings for transplants, you can see pretty much every one of them that qualifies will say something to the effect of consider under a disability for a year after receiving the transplant, which basically tells Social Security, come back and reevaluate after a year to see if the transplant is taking or if it is actually failing and the body's rejecting it. As a specific example I can give, I had a client years ago in one of my first CDR cases, as a matter of fact, which I'm going to talk about in a second, how that process works, at least from an attorney's perspective. But I had a client that was previously found disabled on the basis of having received a transplant. I believe it was a liver transplant. And the person was doing okay, not great, not as bad as they had been doing, but not to the point that their disability was called into question until 10 years after that initial determination. And they suddenly came back in and thought she was doing better enough to return to work, and they terminated her benefits. And we had to appeal at many different stages, including an appeal up to federal court. But by the end of the whole thing, she had basically gone into complete rejection and failure once again. So it kind of defeated the purpose of saying that she had improved. And I wouldn't doubt for a moment that the stress toll that it took on her is partly what led it to getting to that point. So, just because you meet a listing as the basis for being found disabled doesn't mean that you will automatically improve the minute they say you've improved and continue improving. Medical improvement is determined using a comparison point date, CPD, which is the date of the most recent favorable determination in which you were found disabled and entitled to benefits. Now, I emphasized that earlier because, again, while for most people that is the point where your claim is first approved, there are also instances where they do a CDR and find that you're still disabled. And on that date, that becomes your comparison point date, not the date you were originally approved for benefits. And in a little bit, you're going to find out why that's important as well. Now, with a CDR, this is where it's a little different too. We're going to talk about this on an upcoming slide. There is actually, unlike the initial determination where there's only a 5-step sequential evaluation process, with a CDR, there's an 8-step sequential evaluation process done at the initial determination, or excuse me, done at this stage. And the comparison point date and the concept of improvement become the front and center focus. So they look at how you were doing at the point of the comparison point date, and then they look to see if you've had improvement from that date forward. So let's go over the 8-step sequential evaluation process. 1 is the same as the 5-step. Are you currently working or performing SGA? 2, is an impairment listing met or equaled? So especially if you were approved on that basis, they're going to look to see, do you still meet or equal the listing we found before? Step 3, has medical improvement. And by the way, at any of these steps, if you're working and performing SGA, you're no longer disabled. So you want the answer to that to be no. For question 2, is an impairment listing met or equaled? If that's yes, then it stops there and you're still disabled. So if not, step 3, has medical improvement occurred? If no, then you're still disabled. Step 4, is medical improvement related to the ability to work? If no, you're still disabled. If yes, Is there an exception to medical improvement? Now, this is, and I apologize for there's a little typo here. This section of the federal code, 404.1594 F5, talks about what these exceptions are. So I did not list them out because it was a little too complicated. I didn't want to go into that for the purpose of this presentation. But basically, if you have advances in medical technology, diagnosis or treatment, if you're going through a qualified vocational rehab program, if you're currently working, if the prior award was in error or was obtained fraudulently, and things of that nature. So if there's no exception, then we go to step 6. Is there a severe impairment still? Because if there's not, then you're no longer disabled. If there is, then we go on to step 7, which is what is your maximum RFC, residual functional capacity, meaning sedentary, light, medium, and so on, and whether you can do skilled or unskilled work and what other limitations you might have. And then last but not least, similar to step 5 at the initial level, is there work in the economy in significant numbers based on the RFC that the person can do? If the answer is no, then they're still disabled. If the answer is yes, they are not. So what can or should you do to prepare for a CDR before and after it occurs? First, very important, do not panic. Because again, this is a very normal and common part of the disability process, and it happens to many people. And one thing I didn't mention before, by the way, is something that can typically trigger it. Generally, if you are a younger individual, meaning younger than age 50, that's going to typically, unless you clearly have the type of impairment that is definitely not going to improve, is progressive in nature, is terminal even, God forbid. If you're under age 50, that's pretty much an automatic guarantee you're going to be reviewed at some point. If you're over age 50, you could still be reviewed, but it's less and less likely the older you get. But again, do not panic. Step 2, or suggestion 2, if you had an attorney representing you before, you should contact him or her for immediate assistance. And if they won't help, try to find another one. If you can't find one, again, see number 1 above. Still don't panic. Now, I say if you can't find one because it's difficult for me to admit this, but there are less and less attorneys out there than I realize that will do a CDR, even for their own previous client that they got approved for benefits. Part of it is because it is a little bit more involved, especially if you have to appeal. And another part of it, which I won't go into detail in for here, is that the fee structure is a bit different with a CDR case versus an initial determination case. And you can't necessarily do it on a contingency basis. That's why a lot of attorneys won't do it partly for that reason, as much as I wish that wasn't the case. All right, continue to live your life, treat with your doctors, follow their medical advice. Don't stray from it. Don't worry if you are starting to improve. That doesn't mean that you're going to lose your benefits. Do what is asked by DDS. Fill those forms out, get them in when they need them. If you need extensions, you can get them. See the CE providers if you're requested to see them. Wait patiently and know that you have options if your disability is terminated or ceased, aka cessation of benefits. And then once that happens, find an attorney to represent you on appeal if possible. Now, if you do get terminated, you may have an easier time finding an attorney to represent you, and I'm going to get to that on the next slide. Continue to assert your disability and lack of significant improvement. You may believe that you have not improved the way Social Security has, and even if your medical records might be suggesting otherwise, don't let them bully you into thinking you're clearly improved more than you know you actually are. Even if you're having good days versus bad days, you probably know your bad days are still outnumbering the good ones. Get support from treating medical providers as often as you can. Get statements from them if you can. Get the medical source statement or RFC forms filled out if possible. That will definitely help your cause as well. Additional cessation of benefits and CDR considerations. If you get a cessation of benefits notice, you can appeal, but you can also elect to continue your benefits while you appeal. And generally, you must do that and give notice of it within 10 days of the date you receive the cessation notice. This is one of the most common worries that I see from clients that get a CD or go through a CDR and then get a cessation notice. What do they expect me to do while I'm appealing this? I can't be without my benefits. Well, you're entitled to continue those benefits while you're appealing that determination. But a caution, a huge caution. If you do elect to continue benefits, but your award of benefits is not eventually reinstated, you will face a future overpayment, which can be even more devastating than a cessation. So you have to be mindful of that. That is so crucial. And again, one potential impediment, as I said before, is the attorney's fees work differently. On initial entitlement cases, they are taken on contingency, but on CDR cases, oftentimes, in order for an attorney to get paid, you have to be able to provide a retainer or a down payment with that money being held in trust until the claim is hopefully reinstated or the benefits reinstated, and the attorney can hopefully eventually get you back on track. And then the attorney has to petition for the fees that are being held in trust. But generally speaking, that's how they get paid. Now, if you don't elect to continue your benefits while you're appealing the determination and a lump sum accrual starts, or a lump sum amount starts accruing, I should say, then the attorney could potentially seek the typical contingency 25% rate off of whatever benefits have accrued. That's a potential big if. Some final thoughts, and I'm going to include something that's not in the slides here. Don't be afraid to be reevaluated, but don't be afraid to improve and have a better quality of life. But be aware of your conditions and how they're impacting you after you've been approved, excuse me. One other thing to be aware of too, and this is something I'm going to talk more about in a future video that I'm going to be doing about returning to work after you've been on disability. Because I wanted to devote this one just to what happens if you improve and get told you're no longer disabled. If you do eventually go off of benefits for whatever reason, there are circumstances where you can actually get your benefits reinstated if things go bad and get worse again within a certain period of time. It's called an expedited reinstatement period. And again, it's something I will go over in more detail as it pertains to attempting to return to work after you have been on benefits for a period of time. As always, like I do with every one of my videos, if anyone has questions, you can certainly reach me by any of the methods on the slide at the beginning. You should all have my contact information by now. And I do return calls, emails, and texts promptly, as you know. And with that in mind, that concludes tonight's video presentation. I hope everyone has enjoyed it. I hope you're continuing to get things out of this, and I will continue to post videos as the topics keep coming. If any of you ever want to, I think I've said this on prior videos, if any of you ever want to propose a topic you'd like to see me present on, or that's something you'd like to know more about, please don't hesitate to reach out that way, and I will keep it in my master list of different topics that I do eventually want to cover. Thank you all very much. Have a great evening, and until the next time, to be continued.